That's what she's doing. Hello?
Hello.
Can you hear me?
Yes, I can. Can you hear me?
There we go. Can you hear me?
I can now.
She should be able to hear you. Okay.
Yeah, I can hear you now.
Okay.
Ms. Sybil, I don't know why you are responding to other litigants. Can you see the court?
Now I can. Now I can't. I see some other woman now. I just seen the courtroom, but now I don't.
Okay, you need to adjust your
Now I
screen.
will.
You should be able to adjust the view so that you see the court, because it's two litigants talking to each other. The court's not addressing either of you, actually.
Okay. I can just see the courtroom now. Yeah, the other women are off now. That was weird.
Well, it's not weird. That's how Zoom works. And so when that other person talks, you're going to see them. You're not the only person in the virtual courtroom. Who's the person on the iPhone? Ma'am, what is your name?
Kimberly McLeod. Kimberly McLeod.
Did you have a previous name, last name?
Oh, it's under Kimberly Woods, I guess.
Okay, thank you.
Thank you. I'm sorry.
No problem. Okay, on the record, in the matter of LBNB Funding LLC versus Annette Hill, file number is 23-06226. Council, can I have your appearance?
Good afternoon, Your Honor. Andrew Cates, P78292 for LVNV funding in this matter.
Okay, and Annette Hill is present via Zoom. Today's the date and the time that was scheduled for a motion to set aside the judgment. We did receive a copy of the motion filed by you, Ms. Hill. You indicate in your motion that the motion was entered without you fully understanding the notice pursuant to the 7-day rule for entry of order. And that you indicate that the money that you're being sued for isn't your debt, that the account was fraudulently opened without your consent back in 2019, and the account was charged off after 6 years. And you indicate something in reference to a statute of limitations, and you said now the charge off was, I believe that says lifted, and now you're being sued. Did I accurately understand your motion, ma'am?
Yes,
So
it is,
can you hear
Your
me?
Honor.
Oh, okay. And so let's see. You were served with a lawsuit, ma'am?
Yes, I was.
And so it looks like we held a hearing back on February for a joint pretrial statement. Then there was a motion that was filed back in the spring for summary disposition. Did you get a copy of that motion?
No, I didn't get it. They said that they mailed it to me, but I didn't get it. I'm having an issue with the mail delivery, with me getting most of my mail.
What is your issue with your mail delivery?
There's sometimes that I have like information delivery to where you can sign in to the postal service and they'll scan in the documents that you're supposed to receive. And so when I don't receive them, I'll put a checkbox on that item that I have not received. And so the post office is aware of it because I've been complaining for over 2 years about me not receiving different mail items that were delivered to me and that was in that scanner.
You meaning the informed delivery is what you're talking about, that you received an
Yes,
email
ma'am.
telling you it's coming?
Yes, ma'am. I received email of any mail items that I'm going to get. They'll scan it in and send it to me via email.
Okay, yep. So you're indicating that you received an email telling you you had something coming from this attorney and you just never received it?
That's correct, Your Honor.
Okay, and so if you received an email that told you had something coming from the attorney and you never received it, what did you do after that to ensure that you get a copy of the mail that should have come to you?
The postal service just told me just to mark it that I didn't receive it, and then that they will investigate it.
Okay, but you're being sued and you knew that, correct?
Yes, but I didn't know what it was. I didn't know if it was a box for a hearing, so I did call. I called the Michigan. I forgot the name of it, but anyway, I called legal aid is what I called. I called them to see if they can help me with the case, and then that's when I found out.
I didn't ask you about all that. What did you do to get the mail that was coming from the attorney? You knew you were being sued.
I
You knew the names,
got it.
and you knew you were being sued. You knew you were being sued, and you knew the names of the law firm that was suing you because you appeared in this court before. You completed a joint pretrial statement.
Yes, ma'am, and I called.
Wait, you talk over me one more time, and I don't need to hear anything else, okay? You got the name of the attorneys that was suing you. You filed an answer. You used the name of those attorneys in your answer, and you referenced the account number. if you have informed delivery that tells you that you have mail, incoming mail that should be coming from these attorneys and you know you are being sued, why did you not call the attorneys when you didn't receive the mail?
I did call the attorney office.
Okay, so
them.
that's my question. What did they tell you when you called them?
They just told me that a motion was made and that I needed to contact the courts. And that's when I called down to the court office to where they issued the summary, and the summons, I should say. And that's when I found out that, you know, certain things was filed.
So why didn't you appear for the date of the hearing?
The date of the hearing was on, which one hearing are you talking about, Your Honor?
You just told me you called the court to find out about the mail that you were missing. That mail was in reference to the motion for summary judgment that the plaintiff filed against you, that you said you did not receive. Once you called the court, why didn't you appear for the hearing after that?
I did appear. If you talk about the February 26th hearing?
No, I'm talking about the hearing after that, because you received service on the motion for summary judgment, and that was back in April.
Okay, let me find that paperwork to see.
You also received a notice of hearing for that same motion, and that notice of hearing came to you back in April, stamped by the court.
Okay, I'm looking for that because I appeared. Let's see, when did I appear? As far as I remember, I did appear.
You did not appear for that date, ma'am. I was present. The attorney for the plaintiff was present. You were not.
Okay, I didn't know about the April one.
Well, we sent you a notice. So you want me to believe that you got mail sent to you from the plaintiff? You got mail sent from the plaintiff and you didn't receive it in April. Then you got mail from the court. You didn't receive it, but you knew that the thing from the attorneys was coming. So you called the court and they told you about the summary judgment, but you didn't come for the court date. And then after that court date, there was a hearing and you received another mail about an order under the 7-day rule. When you received the order under the 7-day rule, why didn't you call the court?
I did call the court and they didn't tell me anything about a hearing. They just said
you had already missed the hearing by then. You had already missed the hearing by then.
Yes, that's when they told me that a judge was. Yes, that's correct. Because I didn't know about that hearing, the hearing in April, but I would have attended.
You also filed an answer in this matter, and you never alleged in your entry that this was a fraudulent account. Why is that?
I did tell them in the beginning on for the answer for the February 2nd, and we appeared in court. I did say that that was a fraudulent report. I don't even know the name of the person who did it. I don't even have the account number. I don't even know what retailer it is, another, because it was not done by me. I do have identity theft. I spoke to the attorneys and told them that in the beginning. Yes, I did.
Okay, lastly, I have proof of service that you were served with the motion for summary disposition. It says you were served on the 19th of April. Let's see. Your address is 1182 West Edgewood, apartment 1.
Yes, ma'am. Yes, it is.
Okay. I have no reason to believe that you weren't properly notified that these dates were coming, and there's multiple reasons why I am confident that you had reasonable notice. And A, you appeared for a pretrial before this court. I told you the purpose of the pretrial. I advised you that you will get a scheduling order after that, which will tell you your next dates. after that pretrial that you appeared to in April, and that pretrial was actually in February, I believe, you then received notice of the motion for summary judgment. You've indicated to the court today that you received that notice because you knew something was supposed to come because of your informed delivery feature for the mail. When you did not receive the information that was coming in the mail, I don't believe that you exercised your due diligence to follow up with the attorneys to find out, what did you send me? I did not receive it. You knew something was coming, you didn't get it. You don't call the court asking for it. You don't call legal aid, they don't have it. You call the attorneys. What I was supposed to receive some mail for, I'm having an issue with my mail for the last 2 years. Can you please send me a copy of what you sent me or email it to me? That did not happen. Outside of that, after you failed to appear for the court hearing, there was a judgment under the 7-day rule, which also came through the mail, same email, same mailing address that your motion was sent to. And we did not get a responsive motion to set aside the default or the judgment. You would have needed to appear to the court, fill out some paperwork. If you called the court, like you said you did, after receiving that judgment under 7-day rule and indicate to them I didn't make it to a court that I didn't know anything about it, they would have given you such options and you could have filed that. I don't have that. So the only options now, ma'am, is to speak with Mr. Katz to see if you all can come to a resolution or if there's any other recourse as it relates to a fraud packet. I don't know what information you may have sent him because we don't have it in our court record. I just have an answer from you from this winter indicating that it was not your debt. You didn't necessarily use the terminology that you used in this last filing. But if you're going to represent yourself, it's your responsibility, ma'am, to get an understanding of what these things are that are coming to you so that you don't miss important dates and deadlines, because there's not always an easy recourse to set it aside. So what I'll do is I'll put you and Mr. Katz in a private meeting room. You all can talk about potential resolution of the judgment. And if you can't come to your own agreement, then I'll make my final ruling, okay?
Okay, thank you, Your Honor.
Mr. Smith, are you all set in the breakout room?
No, Your Honor. There was a third party off camera that began yelling questions at me. I asked the person three times, whoever it was, 3 times to not interrupt, that I had to conduct an examination. It just got to the point, it became so unruly. I came back to the courtroom. I'm not even close to being done with Miss Wood. Is she still in? There she is. Okay. Perhaps maybe the court can give some direction as to how this is to be conducted. I can't have someone off camera interrupting the flow of the examination.
Miss Wood, your device is muted. Can you unmute, please? Okay. Anybody here for Lansing Automakers?
I see Jessica Sybil is here, and that was another one of my 2 o'clocks.
Oh, okay, sounds good.
Hello?
Okay, can you hear me, ma'am?
Yes, ma'am.
Okay, Miss Woods, give me your updated last name again.
Kimberly Woods McLeod.
Okay, Miss McLeod, this is a debtor's examination that you're here on a case from 1996. They're trying to recover judgment on this matter. And so your responsibility is to answer the questions of the attorney. And I'm going to place you under oath in just a moment. And so I don't know who's in your background. Is someone helping you operate Zoom?
Yeah.
Who is that?
There.
Who's helping you?
My daughter,
Okay.
ma'am.
Okay, your daughter is not to be speaking during this examination, and just so you're clear, the ability to appear via Zoom, that's not a right that you have, it's a privilege. But if we can't conduct this meaningfully via Zoom, then I'll have to order you in person, okay?
Yes, ma'am.
So that means whoever's in the background, and if it's your daughter, that they need to be quiet while these questions are being asked and answered, okay?
Yes, ma'am.
Raise your right hand, ma'am. Do you solemnly swear or affirm to answer the questions truthfully and honestly under the penalty of perjury?
Yes.
Thank you. I'm going to put you back in the meeting room so that you can complete your examination.
Thank you, Your Honor.
Are you all set, Mr. Smith?
I am, Your Honor. There are some documents that are responsive to your subpoena. I'm going to get in writing to her, remind her where to send those. And we should, I think, in light of how the exam went today, if we could get a follow-up or control date, and I anticipate having more questions once I receive the financial information from this defendant.
Okay, how much time do you think you need? You said 30 days?
I think 30 days is enough time to get me the documents. So at any point after that, Your Honor.
September 30th at 2 will be the control date.
Thank you, Your Honor. And then, Ms. Woods or McLeod, if the documents are received by me prior to that date, and I can contact the court to cancel it. So it's important that you get me those documents. That way you and I don't have to come back. But if I don't get the documents, you and I are going to end up here at the end of September, okay?
So if I get them before then, I just mail them to your office?
Yep, those instructions will be in the letter. If you have questions about the letter, when you get it, my phone number is there. Call me. I'll do my best to answer any questions that you have.
Thank you.
Okay, thank you, ma'am.
Thank you. You're all set, ma'am.
Thank you, ma'am.
You're welcome. Okay, and then Ms. Sybil, Mr. Smith, you want her to go in the room with you as well?
I think on this, Your Honor, well, yeah, it's a show cause. She didn't produce certain documents. Why don't you give us a breakout room? I can talk to her. Maybe she and I can work this out.
Okay, sounds good.
Thank you, Your Honor.
You're welcome. You just have to return to breakout room. Yep. Okay, we're back on the record in the matter of LVNV funding versus Annette Hill. Counsel, you and her have spoken. Did you come to a resolution at all?
Yes, Your Honor, we did come to a resolution. At this point, the defendant is agreeing to pay this balance at the rate of $20 a month, beginning the 15th of September, and due every 15th of the month until it's paid.
Is that correct, ma'am?
Yes, Your Honor.
Okay, so there will be a order for payments entering the amount be $20 per month beginning September 15th, counsel?
Yes,
And she's gonna make those payments to your office?
yes, to the Russo Varchetti and Olivier office.
Okay. Do you have any questions for the court today, Ms. Hill?
No, I don't.
Okay, so for the record, the motion to set aside the judgment will be denied, and there will be payment order entered for you to make monthly payments beginning September 15th, $20 per month payable to the plaintiff's counsel. And so long as you're in compliance with that, you won't have to deal with garnishment of your wages, okay?
Yes, ma'am.
Do you have any questions at this time?
No, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor, thank you very much.
Thank you, you're all set.
Thank you.
Okay, are you all set, Mr. Smith?
I am, Your Honor. We got it worked out. She's going to put the employment information, paycheck stubs, et cetera, in the mail to me today. I don't need a new date. I think she and I are on the same page, and I'll get everything else worked out with her off the record.
Sounds good, then you're all set.
Okay, thank you, Judge. Have a great week.
Same to you.
You
Ms.
bet.
Sybil, you're all set.
Okay, thank you so much, Your Honor.
Thank you,
You're
Jessica.
welcome.
Thank you. Bye.
Counsel, you're here on behalf of Capital One.
Yes, Judge, how are you?
I'm well, how are you?
Not too bad.
Okay, Danielle Field, or Falls, that is?
Yes, I'm here.
You can start your video. Okay, Ms. Falls, today's the date that's scheduled for a pretrial. This is a civil matter. I'm gonna put you and the plaintiff's counsel in a private meeting room so you can complete a joint pretrial statement. That's what we're going to use to kick out any scheduling dates and deadlines that you're going to have. You all are also free to discuss possible resolution of this matter, okay?
Okay.
Let's see, and then if you have any issues, you can return back to the virtual courtroom.
Okay.
Okay, are you all set in the breakout room?
Yes, Judge, we have a resolution.
Okay, and you want to put that resolution on the record?
Yes, Judge.
Okay, on the record in the matter of Capital One versus Danielle Falls, file number 24-03974, council appearance.
Michael Kirschenheiter for the plaintiff, Your Honor, P75722.
Okay, and again, Ms. Danielle Falls is present via Zoom without counsel. She's representing herself at this time. You all have come to an agreement on or to resolve the case?
That's correct, Judge. The parties have agreed to enter into a consent judgment. Damages in the amount of $1,918.16, which is the amount of the lawsuit, plus the court cost of $124.25. It's a total judgment, $2,042.41. And defendant's going to pay $50 a month. Her first payment she actually made on July 30th. So that was applied to the account. And her next payment will be August 30th. And the 30th of each month thereafter, obviously the 28th in February. We can file that order under the 7-day rule, or I can sign for defendant. I forget how Your Honor wants that done.
So whichever works to make it most convenient. So Ms. Falls, is what the attorney states as to how you want to resolve this, is that accurate?
Yes, it is.
Okay, and so he's going to prepare paperwork indicating that you are agreeing to judgment by consent and that the amount owed is $1,918.16 plus court costs $124.25, and that you'll make payments of $50 per month already beginning on the 30th of July, and that those will continue monthly on the 30th of the month, obviously 28th in February. And do you give him permission to sign a consent judgment on your behalf that states this information?
Yes.
Okay. Do you have any questions for the court today?
No.
Okay. Any additional matters for the record, counsel?
No, Judge. Have a wonderful day.
Thank you. Same to you both.
Take care.
Thank you.